Good evening, everyone. Goeienaand almal, baie welkom hier by ons, Mweni. My name is Nicholas Smith. I'm the Dean of the Faculty of Law, and it gives me great pleasure to welcome you to this event tonight, the Gys Steyn Chair in Financial Regulation Law inaugural public lecture. I would like to welcome some of our guests, especially, if you allow me. Of course, first of all, our keynote speaker, Unathi, Kamlana. Welcome here in Stellenbosch and also here at the Ou Hoofgebou. We already enjoyed a lovely dinner together last night, and we're looking forward to listening more to you. I want to say a special welcome to the FSCA staff who's here tonight. There's quite a few of the staff members who's joining us, and we're very happy also that you could be here. I want to say a special word of welcome to our SU Law trustees, and they are sitting quite close to one another, so I can say to Gerard Liver, Chris Otto, Michileroe, welcome here. Thank you for your support. I want to welcome George Steyn on that side. I want to welcome previous Deans of Law of this faculty, Gerard Liver and Andreas van Wyk. Welcome here. I want to welcome all our colleagues, students, people from the banks, the financial institutions, our friends of the faculty. We are very, very happy to see such a good turnout tonight, and we hope that you will enjoy the evening with us. Professor Johan Scholes will be introducing our keynote speaker, and he will also say something more about the Gys Steyn Chair. So I just want to say very briefly that it's one of the aims of our faculty to host these public lectures. Because public lectures, of course, gives us an opportunity to share our expertise and our knowledge with a broader audience than might normally be the case. So we achieve quite a few things by doing so. For example, we manage to share scientific knowledge in an accessible manner. We manage to stimulate discussion and debate on very important and topical matters. And this is something that the Department of Mercantile Law is especially good with. We manage to foster networking and having good conversations outside in the quad, usually over some refreshments. The topic of tonight's lecture, Retirement Savings at Risk, Legal Safeguards Against Pension Arrears, is really a matter of great importance, not only from a regulatory perspective, but also from a social protection perspective. So I personally is looking forward to this address. I must say that this is the last public address for 2024, so I want to take the opportunity to thank all of you for your support in the last year and for attending our events, being part of our community. We're looking forward to making a really meaningful impact in the field of financial regulation law. So we're really excited to conclude this year's series of public lectures with the Financial Regulation Law one. I want to invite Professor Johan Scholes now to the podium, and he will also say something more about the order of the rest of tonight's events. Welcome.
Thank you very much, Nicola, Professor Smith. Good evening, everyone. My name is Johan Scholes. I'm honored to be the first incumbent of the Gys Steyn Chair in Financial Regulation Law at Stellenbosch. This research chair, which will focus on various aspects of financial regulation as a prerequisite for economic stability and growth, is the first of its kind in South Africa, and I'm very proud to be that incumbent. However, it does come with responsibilities and expectations. The chair will incorporate aspects such as the economics of the financial sector, models of regulation, regulation of different risks in the financial sector, and regional and international financial regulation law. One of my tasks is to create a knowledge hub around which more focused expertise may be co-opted as needed. The way I see it, the chair is a multidisciplinary position that will aim to provide linkages between various fields: law, accounting, economics, banking, governance, risk management, as well as between various entities, regulators, financial institutions, law firms, exchanges, intermediaries, prosecuting authorities, and academic institutions. While no one person can be an expert in everything, and I certainly am not, I see my extensive network in the legal, regulatory, and academic world as one of the assets that I can contribute to this position. And you are here tonight. You are my network. Thank you. One of the chair's focal areas will also be the monitoring of global developments in the regulation of digital currencies, open banking, blockchain, consumer protection, sustainable financing, the regulation of carbon markets, ESG, that's environmental, social, and governance criteria, especially in the regulation and investment areas, and the regulation of climate risk management by banks and insurers. We live in a global society, and our financial markets are largely interlinked. Financial regulation can no longer be approached on a parochial basis. Recent events, such as the unfortunate grey listing of South Africa by the Financial Action Task Force last year, have affected the country's excellent international reputation for prudent and effective financial regulation. This chair, as a hub of expertise, hopes to play a key role in bolstering South Africa's position through impactful research, publications, focused high-quality teaching, the development of a bespoke LLM course in financial regulation, industry-relevant short courses, thought leadership, high-level conferences, and colloquia. Now, I don't know when I'll be able to do all those things, but it's a very ambitious list that I've drawn up for myself, and which I must say, to a certain extent, has been imposed on me. But I do so with pleasure. As this is our first public lecture, please indulge me and allow me just a few personal words of thanks. I know Sedula will do it very ably afterwards and more fulsomely, but I also just firstly want to thank the members of the Stellenbosch University Law Faculty Trust for their role in the establishment of the chair, and Mr. Gys Steyn, whose very generous endowment made it possible. Colleagues in academia, practice, and the financial service industry and regulators who are here tonight, I appreciate your support. I would like to thank in particular my former partners at Weber Wenzel who are here, some traveling, I'm sure, traveling from Johannesburg. Thank you very much for your support, not just tonight, but over the years. In a similar vein, thank you to my friends who have made a special effort to be here tonight. I am deeply indebted to my Stellenbosch colleagues for doing me the honor of appointing me to this illustrious faculty, and for making this middle-aged inkomer from Johannesburg and a taki to boot feel so welcome. I know how to be an attorney, but I'm still learning the ropes of academic life. Thank you for your patience, collegiality, and help. Annette van Tonder, my PA, deserves a special mention in dispatches. Your hard work and arrangements behind the scenes ensured the success of this evening. And last but not least, all the members of the Financial Sector Conduct Authority who are here tonight and who helped to make this function possible. My interaction with some of you go back some 25 years. Not always easy, but always cordial. Thank you and welcome. And now I would like to introduce you to the person who will deliver the very first Gys Steyn public lecture. Mr. Unathi Kamlana is the Commissioner of the Financial Sector Conduct Authority, in which post the late Mr. Tito Mboweni, then the Minister of Finance, appointed him in 2021. The FSCA is one of the two main pillars of financial regulation in South Africa, the other one being the Prudential Authority. Prior to his current appointment, he was the head policy, statistics, legal and industry support for the Prudential Authority in the South African Reserve Bank. He started his career in banking, holding various roles with the Standard Bank Group, and subsequently he joined the public sector and spent close to 6 years at the National Treasury, starting in tax policy and later financial sector policy. Immediately prior to his appointment to the Reserve Bank, he was the Chief Director Financial Markets and Stability in the Treasury. He joined the Reserve Bank in 2011 to champion the regulatory reform project for the implementation of the so-called Twin Peaks model of financial sector regulation. People ask me why it's called Twin Peaks. Now, those of us of a certain age can remember a television series called Twin Peaks and Angelo Badalamenti's music. But when I say to my students, why do you think it's called Twin Peaks? It means nothing to them. But there are two Twin Peaks and there are two pillars. Unathi was appointed also as the Deputy Registrar of Banks from 2016 to 2018. Mr. Kamlana was a member of the Standing Committee on the Revision of the Banks Act and a member of the Standing Committee for the Revision of the National Payment System Act and co-chair of the Financial Markets Implementation Committee. He has also participated in various international forums and was a member of the Policy Development Group of the Basel Committee on Banking Supervision and the Policy Development Committee of the International Association of Insurance Supervisors. He is currently a member of the Regional Consultative Group for Sub-Saharan Africa of the Financial Stability Board. Unathi grew up in Dansane in the Eastern Cape and then went to Rhodes on a scholarship. This is where he met his wife, Kelly Bugile, who is a diplomat in the United Nations in New York, and they have 2 sons. He studied economics and taxation at Rhodes University and holds a Master's of Economic or Commerce, or MCOM, in taxation. He also holds a Master of Science or MSc in Finance in Economic Policy from the University of London at their prestigious School of Oriental and African Studies, SOAS, and an HDIP tax from WITS. He has attended various professional development courses in finance, taxation, and regulation, including at Duke University, the Federal Reserve, the University of Cape Town, and the Strategic Management and Regulatory Agency's Executive Education Program at Harvard. He's a World Economic Forum Young Global Leader. The only blot on this otherwise perfect copybook is that he's a staunch Kaizer Chiefs and Manchester United supporter. We are very honored to have someone of such stature and caliber to deliver our first public lecture. Mr. Kamlana, we look forward to your address.
Ladies and gentlemen, good evening. Let's try that again. Good evening, ladies and gentlemen. Just on this issue that I think does require to be addressed with regards to allegations of personal questionable choices of soccer teams that I support. I neither confirm nor deny such allegations, but I reserve my rights to defend myself at an appropriate forum, should I be required to do so. Thank you very much, Professor Scholes, for the introduction. And it's really good to be here. Really appreciate the opportunity to come and engage in this fashion with yourselves. And I'm looking forward to the conversation and questions afterwards. Well, it's been said that lawyers charge by the hour and twice by the verb. So naturally, as an economist, I was a bit hesitant to accept an invitation from a lawyer to come and address a group of lawyers. But I was given the assurance that I wouldn't be receiving an invoice after this evening's address. Although, of course, knowing lawyers, I should have probably insisted on receiving such an undertaking in writing. But all the same, it's really good to be here this evening. It's a real privilege and an honor for me to deliver this inaugural annual lecture of the Gys Steyn Chair in Financial Regulation Law here at the Stellenbosch University. I would like to begin by thanking Prof. Johan Scholz and Professor Nicola Smith, the Dean of the Law Faculty, for extending this invitation. Let me congratulate you for your vision and foresight in establishing this chair. In my view, it is a pioneering initiative which can only serve to improve the practice and outcomes of financial regulation and increase confidence in our financial markets and the financial sector as a whole. There is a wide array of topics that I could have chosen as themes for today's lecture. I could have, for example, explored the developments around the regulation of digital assets, specifically our approach as the FSCA to the regulation of crypto assets, a rapidly evolving and much debated, not just here, but around the world, a regulatory topic, which is especially topical now, especially with the change in leadership across the Atlantic and the rapid rise in the prices of these digital assets. I could have also focused on conduct risks in financial institutions in general, their implications for financial customers, and their relevance for both micro and macro prudential outcomes. Perhaps I could have also unpacked our approach with regard to the regulation of financial markets overall, a critical pillar in ensuring the integrity and stability of our financial system. Or I could have spoken about the progress we are making towards addressing the shortcomings identified by FATF, which led to the country being grey listed in 2023. We can pick up on all of these topics at no additional cost during the cocktail function that will happen afterwards. I'm made to understand that there will be some liquidity provision by the university later after the lecture. But for the purposes of today's lecture, I have decided to address an issue that is gaining increasing prominence in our public discourse, including in our parliament, and especially in the context of the introduction of the two-pot system in terms of our retirement funding arrangements. And that question is, how effective are our laws in protecting retirement savings, particularly in the context of rising pension fund arrear contributions? As you know, many South African households struggle to save enough for retirement, with less than 10% able to retire comfortably. On average, household savings amount to just over 2% of GDP, with nearly 60% of these savings locked in contractual retirement funds. This heavy reliance on retirement funds makes it really important for these funds to be well protected and well managed, ensuring that contributions are made consistently and in full. Because at the heart of our retirement fund system are tax-subsidized contributions aimed at building a safety net during an individual's active working life, in order to provide for the financial needs and provide a cushion upon their retirement. This tax subsidy approach to accumulating what is really personal savings makes it all the more important for us as a regulatory authority to ensure adequate regulatory outcomes for members of retirement funds. One of the structural changes in our retirement funding system was the shift from the defined benefit funds, the DB funds, to defined contribution funds, the DC funds, a shift which took place in the early 1990s. The shift meant that members of retirement funds began to shoulder more of the financial risks associated with their retirement savings. Under DB funds, retirees received a guaranteed pension payout based on factors like salary and years of service, with the employer bearing much of the investment risk. However, with the move to the DC funds, the risk responsibility shifted significantly to members of retirement funds. The retirement benefits in DC funds depend on the amount contributed by the employer and the employee, as well as the market investment returns on those contributions over time. As a result, timely and consistent contributions are critical to the ultimate value of retirement savings over time, and by extension are significant determinants of whether or not an employee secures a comfortable retirement. When an employer fails to make timely payments into pension funds, there is a major negative impact on the employee's retirement savings, potentially undermining the very foundation that many South African workers depend on and leading to a direct loss of growth potential of their savings and leaving workers vulnerable to financial insecurity in their retirement years and eroding their confidence in the financial system. This negative impact on the value of retirement savings is what has made this issue of arrear contributions increasingly problematic and topical for our retirement system over the recent years. In terms of the numbers, currently 7,770 employers in the public and private sectors have been reported for failing to make timely pension contributions. 7,770. Of these, 36% of these cases occurs in the private security sector. The latest data indicates that the total arrear contributions amount to some 5.2 billion rand. When arrears accumulate in this fashion, the trust that retirement fund members place on the retirement system meant to provide for them in their later years is severely affected. It's important to provide some context here. Sometimes it is the economic hardship faced by the employer that results in them incurring arrear contributions. Sometimes it is the cyclical nature of the business and the concomitant volatility of income that contributes to this problem. This is especially relevant in the private security sector, given the nuances in that sector. The COVID-19 pandemic also exacerbated the issue of arrear contributions, with many firms just simply struggling to survive. However, it is sometimes sheer management ineptitude and in some instances corruption. And we have seen this in both the private and public sector. I'll come to this point when I talk about pension arrears in municipalities. The point we are making, though, is that whatever the reason, pension fund arrear contributions, should they reach a prudentially significant amount, could destabilize the broader retirement ecosystem, as pensions rely on steady contributions to maintain liquidity and fulfill their obligations. They may become strained when contributions are inconsistent or delayed, and this in turn could limit their ability to invest in necessary long-term projects, diminishing their role as major institutional investors in the economy. So it's not just the employees who suffer. The entire retirement system becomes more vulnerable This is why addressing this issue really requires a regulatory and legal response that is comprehensive, closes enforcement gaps, ultimately secures positive outcomes for retirement fund members. Let me turn now to this issue of pension fund arrears in municipalities. This issue of arrears in municipalities is fast becoming a pervasive phenomenon and a deeply troubling issue within the local sphere of government, with potentially devastating consequences for employees of municipalities in terms of their retirement savings outcomes. Across the country, just under 150 municipalities have been implicated in failing to remit pension contributions deducted from employees' salaries, already deducted from employees' salaries, with the total amount of unpaid contributions estimated to be about 1.4 billion just for the local government sector. One particularly egregious practice contributing to this is the recycling of employer pension contributions, a financial mismanagement tactic where municipalities, instead of forwarding contributions to pension funds, divert those funds for operational expenses or even to pay salaries. This practice not only breaches fiduciary responsibilities and duties, but also exacerbates the financial instability of the municipality because it creates a backlog of unpaid pension obligations that accrue interest and penalties over time. It places employees in an untenable position where their long-term financial security is sacrificed to meet short-term financial needs within the municipality. And importantly, it increases the contingent liabilities of the state. Encouragingly, we are beginning to see some actions by law enforcement agencies to hold those responsible for these practices accountable. This progress is reflected in the enforcement actions targeting both individuals and municipalities that fail to fulfill their obligations. The DPCI, the Directorate for Priority Crime Investigation, also called the Hawks, have actively pursued cases against municipal officials who have violated the Pension Funds Act. For example, at Stellenbosch municipality in the Northern Cape, 3 senior managers were charged with fraud, theft, and contraventions of the Municipal Finance Management Act and the Pension Funds Act for failing to remit 73.5 million rand in pension contributions between 2018 and 2023. 73.5 million rand, causing severe harm to employees nearing retirement. Such enforcement actions further underscore the importance of holding officials directly accountable for pension fund mismanagement, ensuring compliance with the law, and protecting the value of retirement savings of workers. We hope to see more of these enforcement actions and hope to see and secure convictions as well after they are charged. The question now therefore becomes, are our current laws truly fit for purpose? With this question in mind, let's look at the legal framework designed to safeguard retirement savings and assess its effectiveness in addressing these challenges. The legal framework governing pension funds in South Africa is primarily underpinned by the Pension Funds Act, the PFA. Section 13 capital A of the PFA is particularly crucial as it clearly stipulates the responsibilities of employers to make both their own contributions and those of their employees on time, ensuring that pension funds are adequately funded to meet their obligations. It requires employers to ensure that monthly contributions deducted from employees' salaries are fully paid to the registered retirement fund in which they participate, no later than the 7th day of the month following the month in respect of which such contributions are made. To complement Section 13 capital A requirements, the FSCA further published a conduct standard in 2022, which sets out the requirements related to the payment of pension fund contributions. The standard aims to ensure that the boards of trustees of the fund and employers are fully aware of their responsibilities concerning pension contributions. It requires retirement funds to notify each employer of their duties, obligations, liabilities under Section 13 capital A of the PFA and the FSCA conduct standard before they begin participating in the fund as members of the boards, and to continue providing this notification annually. This consistent communication ensures that employers remain aware of their responsibilities and helps prevent non-compliance, ultimately safeguarding employees' retirement savings. Crucially, the Pension Funds Act places a responsibility on the board of trustees of pension funds to ensure compliance with contribution requirements and to facilitate the timely payment of contributions. Over the years, many boards have actively pursued defaulting employers, either by referring cases to the Office of the Pension Funds Adjudicator or by initiating civil action to recover unpaid contributions. While civil action has proven effective in many cases, it is not without its challenges. For smaller funds, the pursuit of legal action can be financially burdensome, as associated costs can impact the retirement savings of members. As a result, some umbrella funds, which pool the assets of various employers into a single pension fund, have, in line with their rules, resorted to terminating the participation of employers if arrear contributions remain and persist outstanding after a specified period. When an employer is terminated from an umbrella fund, the fund may undergo partial liquidation, which can leave members without adequate retirement coverage. This action can lead to members being unenrolled and negatively impact their financial security, especially if their share of the fund does not include arrear contributions at the time of withdrawal or transfer, as defined by the rules of some funds. Ultimately, the focus can sometimes shift towards managing the risks and costs of litigation and the fund liquidation, rather than prioritizing the recovery of arrears, potentially compromising the financial security of members. Ultimately, the role of the board, and we understand this, we appreciate this, the role of the board is one of balance between taking all reasonable steps to recover arrear contributions and ensuring that those steps do not inadvertently harm the financial interests of the members they are meant to protect. It is undoubtedly a challenging role that requires a deep understanding of the fund's own circumstances, the legal environment, and the potential impact on members. I'll come back now to how we are thinking about making some changes in terms of our approach to enforcing the fiduciary duties of members of boards of trustees. We talk now about the role of members. Coming to the role of members of retirement funds, members are not without powers when it comes to addressing issues of arrear contributions. While it is established law that arrear contributions are owed to the fund and that the fund itself has legal standing to institute legal proceedings as a creditor, there have been important legal developments that strengthen the role of individuals in this regard. A significant case in point is the Mafuku Security Patrols Pty Limited versus Moketsi and others, where the High Court affirmed that members have the standing to bring an application for execution against an employer's property when contributions are in arrears. The right arises particularly when a member has obtained a favorable determination from the Office of the Pension Funds Adjudicator, confirming the employer's obligation to pay. The judgment empowers members by allowing them to directly seek enforcement of their rights. By implication, it suggests that members could also execute civil action for the recovery of arrear contributions in their own names, providing them with a direct avenue for addressing non-compliance by employers. The legal recourse is significant because it offers individuals an additional layer of protection and ensuring that they are not entirely reliant on the fund or on the board to take action on their behalf. Important to just say here, this approach is obviously not without its risks.
Net die voor de vraag dat we moeten bespreken. Dat is voor jou als sterren. Oké.
Right. Now, let us turn our attention to a critical aspect of accountability: personal accountability. The legal obligation to make pension contributions does not rest solely on the company as a corporate entity. Rather, Section 13 capital A subsection 8 of the Pension Funds Act extends personal liability to directors and senior management. This means that those involved in the financial affairs of the employer can be held directly accountable if the company fails to pay over pension contributions as required. This underscores just how important it is for directors and senior management to take their fiduciary duties and responsibilities seriously. Such a provision ensures that directors and senior managers cannot hide behind the corporate veil to evade their obligations, particularly in cases where employee contributions are deducted but not remitted to the retirement fund. The principle was reinforced in the judgment in the case of Engineering Industries Provident Fund and another versus Pioneer Mechanical CC and another. Here, the court ruled that the sole director was personally responsible for the unpaid pension contributions, despite his argument that the company structure under the Companies Act 2008 shielded him from this liability. The court made it clear the legislature's intent behind Section 13 capital A subsection 8 is unmistakable. This law exists to ensure that retirement funds and their members have a pathway to recover what is rightfully theirs, even if it means holding individual directors to account. In this particular case, the court ordered the liquidators of the defaulting employer to quantify the amount of arrear contributions owed by the employer and pay them to the affected member within a specific period. In the event the liquidators failed to make the calculations as ordered, the member was ordered to return to court with his own quantified amount. The judgment addresses the common issue for employees seeking redress through the Office of the Pension Funds Adjudicator, where employers often fail to provide the necessary calculations for arrear contributions as ordered by the adjudicator, hindering the ability of members to secure execution against them. Furthermore, the Pension Funds Act framework, failing to pay pension fund contributions on time is not just a breach of contract. It's a serious violation of the law. Section 37 classifies the non-payment of contributions as a criminal offense, punishable on conviction by a fine not exceeding 10 million or imprisonment for a period not exceeding 10 years, or both. The strict penalty underscores the gravity with which the law views the failure to comply with pension contribution obligations. The FSCA conduct standard further strengthens this provision by placing a positive obligation on the board of the fund to support contraventions of Section 13 capital A. This report must be made within 14 days of the expiry of the 90-day period, which the non-compliance continues. However, there is an anomaly. While the FSCA conduct standard imposes the positive duty on the board to report such non-compliance with the SEPs as a criminal offense, it does not impose a similar duty to initiate civil proceedings against the employer. And this is important. Civil proceedings are crucial because they can secure actual payment of contributions, thus directly protecting the retirement savings of members. And this gap in legislation means that while a fine can be paid and imposed, this fine is not payable to the pension fund itself. This goes to the National Revenue Fund. Instead, the fine serves as a deterrent to the employer for failing to comply with legal obligations under the PFA. Despite this legislative gap, the deterrent effect of Section 37 remains significant, provided that the provision is diligently enforced. To ensure that this happens, the FSCA is actively engaging with the senior leadership of the SEPs and the NPA to enhance our mutual understanding of the relevant provisions of the pension fund legislative framework, to strengthen and streamline our process of handling reports for non-compliance. These efforts are aimed at ensuring that cases of arrear contributions are treated with the seriousness they deserve, enabling law enforcement to take action swiftly and effectively. What is our role as the FSCA? Our role is one of monitoring compliance with Section 13 capital A of the PFA as it relates to obligations of the funds and ensuring that their boards fulfill their responsibilities in managing contributions. However, the FSCA does not have, this is important to highlight, the FSCA does not currently have direct powers to regulate employers or ensure their compliance with Section 13 capital A of the Act. We rely on the boards of pension funds to take the necessary steps to recover arrear contributions and ensure that the payments are made in accordance with the law. So while we provide oversight to ensure boards act in the best interest of members and report cases of non-compliance, we cannot compel an employer to make payments directly. We don't have such a power. This is the reason we are considering taking greater enforcement action against boards and or administrators who do not act or do not take timely action in the best interests of the members of their pension funds. Recognizing the current limitations in terms of the law, we have adopted several strategies to strengthen enforcement and encourage compliance. One such measure is the publication of the names of non-compliant employers. The first communication was published last year, 31st October 2023, and we didn't sleep that day with everybody calling us, marking the beginning of a series of ongoing publications that list defaulting employers, detailing the duration and the extent of their non-compliance in terms of arrear contributions. The second communication was 26th March 2024, continuing the effort to shine the light on employers whose arrear contributions remain unpaid for extended periods. By publishing these lists, the FSA aims to create a deterrent effect using the power of public accountability to encourage better compliance. This measure is designed to bring greater transparency to the industry, allowing employees, trustees, and other stakeholders to be aware of which employers are not meeting their pension contribution responsibilities and why. It serves as a form of reputational pressure where employers face public scrutiny to their failure to remit contributions on time, potentially affecting their business relationships and standing in the community. The public naming and shaming approach has proven to be effective as a tool and is driving compliance. As a result, following the publication, almost 1,000 employers took swift action to clear their arrears. recognizing the potential reputation damage and legal consequences of their non-compliance. In addition, many retirement funds have used the visibility provided by these publications as leverage to enter into settlement arrangements with defaulting employers, ensuring that the contributions are paid, even if they are paid over time. In more serious cases, funds and members have had to file complaints with the Office of the Pension Funds Adjudicator, seeking formal determinations against non-compliant employers. Some funds have also escalated matters by initiating legal proceedings, obtaining court orders to compel payment, and even open criminal cases with the SAPs against those whose employers disregard their obligations. The publication of these names has also caught the attention of Parliament, political parties, and labor federations. These stakeholders have strongly condemned the employers who failed to meet their pension contribution obligations, further increasing public pressure on them to comply. Their involvement and interest have amplified the visibility of this issue, pushing for greater accountability and reinforcing the importance of protecting workers' retirement savings. The latest communication on defaulting employers is scheduled to be issued later this month as a Christmas gift, continuing to hold employers accountable and encouraging timely payments to retirement funds. Turning now to the evaluation and the efficacy of our legislative framework. Despite a seemingly robust legal framework, which ranks favorably against most jurisdictions, supported by case law, the substantial cumulative amount of arrear contributions owed to non-compliant employers highlights potential shortcomings, particularly concerning Section 13A, capital A of the PFA. This raises questions about the effectiveness of the legislative provisions themselves, or alternatively, challenges in the enforcement of these provisions. The persistence of arrear contributions suggests that while the legal requirements are clear, there may be limitations in the mechanisms available for ensuring compliance and in holding employers accountable for their obligations. A significant challenge within the current framework is that the FSCA has limited jurisdiction over employers. As I mentioned earlier, while the FSCA is empowered to supervise retirement funds and ensure compliance with the PFA, it lacks direct regulatory authority over over employers. Relying on the boards of retirement funds to take legal action against employers, such as pursuing civil litigation or reporting non-compliance as a criminal offense, we still wait that. This reliance on indirect enforcement can create gaps in accountability, as boards may face financial or logistical challenges in pursuing legal action, especially smaller funds with limited resources. There is also a lot of conflict of interest considerations in boards of trustees taking action against employers, as the boards are made up of representatives of employees and of the employer. As such, the lack of a direct, independent jurisdictional authority and independent regulatory authority can lead to delays in the recovery of arrear contributions, compromising the financial security of members. So this issue of powers over employers by the FSCA is crucial, is urgent. To address these jurisdictional limitations, plans are underway, particularly through the anticipated promulgation of the Conduct of Financial Institutions Bill, the COFI Bill, which is still to be tabled in Parliament, hopefully soon. Upon enactment, the COFI Bill will broaden the regulatory reach of the FSCA, bringing participating employers under its supervision as regulated entities, in addition to those currently under oversight. This expanded mandate will enable the FSCA to directly engage with employers involved in retirement funds, enhancing compliance and accountability in a way that suits different circumstances. This extended regulatory scope under the COFI Bill presents an opportunity to collaborate with other oversight bodies to address persistent challenges in ensuring compliance. For example, together with the Office of the Auditor General, we are exploring the potential of applying some of what they refer to as material irregularity framework of audit findings from public entities, where they can identify violations of financial sector laws, and those they can refer to the FSCA to investigate and to take enforcement action. This is very much early days. We're still exploring, but if you take that to its logical conclusion, then you'll be able to get that referral and conclude an investigation and hold people accountable in a certain municipality for not paying over the contributions that were deducted from employees into pension funds. As we move forward, it is clear that this issue requires coordinated efforts and novel ideas and proactive interventions. In addition to the anticipated promulgation of the COVID bill, we are looking to enhance collaboration, as I've indicated, and we're working together with SAPS, NPA, AGSA, Treasury, SARS, and others. The need for a holistic approach is self-evident because of what is at stake. Retirement savings are at risk. In conclusion, I must emphasize this. In the meantime, the primary responsibility for the governance outcomes of retirement funds, including ensuring compliance with the provisions of the Pension Funds Act and other relevant legislation, that resides primarily and in the first instance with the boards of trustees of the funds. Enhancing the powers of the FSCA as we would over employers will not and should not shift the nexus of responsibility away from those entrusted with the day-to-day duty and responsibility to protect the hard-earned savings of members in retirement funds. This appreciation will inform the focus of our future enforcement actions in this area as the FSCA. I thank you very much.
Unathi, thanks for that. And just a small token of our appreciation for you accepting As you heard me say, I have to thank Unathi, and I'm sure you will agree that he addressed us on a very pressing issue, a very urgent problem, and actually it confirms what I felt last night at the dinner we had. It occurred to me that you and your team in the pension regulating sphere may be the dermatologists of regulators. Let me explain, at least for people of a certain age. I'm led to believe that the most annoying medical specialization that you can have done is to be a dermatologist, because at any social event, it doesn't take long for somebody to approach you about some rash or itch or something like that they want to consult you about. And similarly, like I said, for people of a certain age, they would like to know that everything is as it should be with their pension funds. And so it took every ounce of restraint last night that I could muster not to ask you whether everything is fine with my university pension. And whether you had a chance to check if it's okay. But Unathi, when you get back to the office, feel free to check your files. And that, everything is in order. I understand that you exercise the utmost discretion and confidentiality in these matters, but you can blink twice the next time we see each other if everything is in order. Because if not, I have to start looking for a place to sell chicken tikka when I retire. So this is something important. But enough about my retirement paranoia. All that remains for me to do is to thank persons whose contribution makes this public lecture possible. First, of course, I have to thank Mr. Gys Steyn, who unfortunately couldn't be with us this evening. We are incredibly fortunate as a faculty and a university to have the opportunity to establish a chair of financial regulation. While we have had a private occasion to thank Mr. Steyn, I think it only appropriate to again acknowledge his very generous contribution to the faculty and indeed the country. This is a great opportunity that he has presented us with at the faculty, and it's an even greater responsibility that we have to make sure that we establish this faculty as a preeminent institution in the area of financial regulation, not only for the country, but for the continent. There is no point, and as you have heard that what Johan has in mind and what we have in mind, there is no point in being modest about our vision for the chair. There's a Latin expression, gaan groot of gaan huis toe. And we're serious about this. I would like to thank the Dean and the Law Trust for their support and efforts in establishing the chair. And then in no particular order, I must thank other colleagues at the faculty who have worked behind the scenes concerning the arrangements relating to this evening. Alma, Shazleen, Kathy, and Gerda, thanks to the photography and video teams and the communications team from the FSCA, and of course, Dilly, our caterer, who is responsible for the delicious food and refreshments. And then I have to thank two people who no doubt have worked the hardest in putting together this evening. That's Annette and Johan. You can rest assured, given the turnout, that you have indeed arranged a very successful inaugural lecture of the Gys Steyn Chair in Financial Regulation. Last and by no means least, I would like to thank you for attending, both those people who are attending online and of course those who are with us here in person, because that is what makes this event a success. A number of you, as Johan has indicated, have traveled a fair distance, and we hope that you return safely to your homes. So all that remains for me to do is to request that you join us. We have sufficient liquidity in the faculty, and it will be on display in the quad. So thanks.